Good morning, this is your Kelso Report for Monday, October 22nd. I'm your host, Clark Kelso. In our first case today, we are reminded that a defendant who pleads both not guilty and not guilty by reason of insanity should not have the insanity plea placed before the jury in the first guilt phase of the proceedings. Our second case involves the lack of articulable suspicion to detain someone on the street for questioning, and our last two cases today involve development projects and environmental review under CEQA. We begin with the California Supreme Court. In California, when a defendant pleads not guilty by reason of insanity and also joins with it another plea of not guilty, the court bifurcates the proceedings, first trying the defendant on the charges as though the defendant had not made an insanity plea, and then conducts a second proceeding only on the insanity plea. During the first proceeding, in the words of Section 1026 of the Penal Code, quote, "The defendant shall be conclusively presumed to have been sane at the time the offense is alleged to have been committed," close quote. In People v. Mills, the defendant was charged with murder, pled not guilty, and also raised an insanity defense. At the guilt phase trial, the prosecutor requested a jury instruction that the defendant was conclusively presumed to have been sane at the time of the offense in conformity with Section 1026. The defendant objected that the instruction might lead the jury to disregard evidence of his mental illness and its effect on the intent required for murder. Well, the court overruled the objection, gave the instruction on the presumption of sanity, and refused defendant's request for an instruction on the legal definition of sanity. The jury convicted defendant of first-degree murder, and in the subsequent sanity phase found that he was sane at the time of the offense. He was sentenced to a term of 50 to life. Well, on appeal, the California Supreme Court held that it was error for the court to give the jury any instruction on insanity during the first proceeding, since by virtue of Section 1026, the defendant's insanity was irrelevant. No instruction at all should have been given. Now, given the evidence in the case, the court ultimately held the error was harmless. But the court's opinion clearly established that in a criminal trial involving an insanity plea, the court should not give the jury any instructions about insanity during the first phase of the proceedings in the bifurcated insanity defense process. Next, we turn to a case involving lack of articulable suspicion for detention. We see in the press a lot of general talk about racial profiling. We don't actually see that many cases where the courts find that racial profiling has occurred. The 6th District in People v. Walker appears to have found such a case, although the court does not itself identify the facts as involving racial profiling. The defendant in the case, a young black man, disembarked late in the evening of November 2010 from a train at the light rail station in downtown San Jose. He was stopped by a Santa Clara County deputy sheriff who suspected the defendant might have been one of two young black male suspects involved in a sexual battery occurring 1 week earlier at the same station. The deputy asked the defendant to show proof that he had paid fare, and the youth responded by asking why the deputy was singling him out amongst all other passengers. The deputy said, "I have a right to ask you for proof of fare, and you resemble a suspect in a sexual battery investigation." Then the officer asked the defendant for identification. After he was detained by the deputy and produced an identification card, the deputy suspected the card belonged to someone else, which it did, and the youth was arrested. A search incident to arrest yielded cocaine base and marijuana. The defendant moved to suppress the seized evidence. At his subsequent trial, a motion the Superior Court denied, and the defendant then entered a plea of guilty for the drug offenses and appealed, contending that his detention, warrantless search, and arrest constituted an unreasonable search and seizure because the deputy did not have a reasonable and articulable suspicion the defendant had been or was about to be engaged in criminal activity. The 6th District agreed. The officer had the right to approach the defendant to inquire if he would be willing to answer some questions. In this consensual encounter, the defendant had the right to refuse to answer, which is essentially what happened when the defendant asked the officer why he was being singled out. Any further detention at that point required a reasonable and articulable suspicion. The deputy's claim that the defendant resembled a suspect was, according to the court, not objectively reasonable. The common features between the suspect and the defendant were race, gender, and general build. Both were African American males and between 180 and 200 pounds. But the suspect was described as approximately 6 feet 1 inches tall, while the defendant is only 5 feet 10 inches tall, a difference the deputy had noticed. And the suspect was described as clean-shaven, light-complected, and appeared unkempt, while the defendant was of medium to dark complexion, and at the time of the detention was well-groomed and had a mustache and slight goatee. For the court, there simply weren't enough common features to give the officer a reason further to detain and question the defendant. Being a black male of average height and build does not create articulable suspicion. Now we turn to 2 cases arising under CEQA. In this first case, Preserve Wild Santee versus City of Santee, the City of Santee certified an environmental impact report in support of a project to develop some 2,600 acres of undeveloped land. The trial court found a portion of the environmental impact report to be insufficient and opted for a limited remedy, remanding the EIR back to the city to be corrected, believing that the EIR's flawed fire safety analysis was the sole CEQA violation and that the project's fire safety impacts were discrete. But the 4th District ultimately identified additional CEQA violations in the EIR in its handling of the project's biological resources and water supply impacts. And moreover, the 4th District observed a strong interrelationship between the project's fire safety impacts and biological resources, because the preservation of some sensitive species required careful vegetation management through fire, grazing, or other means. As a result of the interdependence, whatever steps the cities took to remedy the EIR's deficiencies in one of the areas could affect the steps the city takes to remedy the EIR deficiencies in another area. They were interdependent. This was therefore probably not an appropriate case for a limited remand, and the Superior Court should have decertified the EIR and set aside the project approval. And that's, of course, what happened. Next, we have up in the 3rd District Court of Appeal another project approval. This time, the governmental entity was more successful. The case is Mount Shasta Bioregional Ecology Center versus County of Siskiyou. In November 2008, the defendant, Siskiyou County, approved a project to expand an existing wood veneer manufacturing facility in order to permit cogeneration of electricity for resale. The Mount Shasta Bioregional Ecology Center and weed-concerned citizens filed a petition for writ of mandate against the county, claiming approval of the project and certification of the EIR violated CEQA. The trial court denied the petition, and the 3rd District affirmed. The plaintiffs argued on appeal that the EIR failed to include an adequate analysis of alternatives and failed to fully disclose, analyze, and mitigate air quality, noise, and water impacts of the project. Although the 3rd District found some minor deficiencies and inaccuracies in the EIR, it ultimately concluded that these minor errors did not prejudice the environmental review process, and the 3rd District gave a green light to the county's project approval. And that's it for today's Kelso Report. Have a great day in the law.